On January 24, 2002, Joseph Fredrick, a senior at Juneau Douglas High School, publicly displayed a banner reading "Bong Hits for Jesus" during the Olympic torch relay through Juneau, Alaska. Fredrick's attendance at the Olympic relay was supervised by his high school. Fredrick's principal, Deborah Morris, told Fredrick to remove the banner in concern that the banner would be interpreted as a school advocating illegal drug activity. Refusing to remove the banner, Fredrick was given a 10-day suspension for violating school policy. Feeling as though his First Amendment rights were being violated, Fredrick took the case to the U.S. District Court of Alaska. The court ruled in favor of Morse, but the U.S. Court of Appeals for the Ninth Circuit reversed the ruling, saying that Fredrick's banner was protected under the Constitution. In 2007, Fredrick's case was brought to the Supreme Court in a 5-4 decision in favor of the school. Major points to their decision was reasoning that it was a school-supervised event. The Supreme Court also referred back to the Supreme Court case of Hazelwood School District versus Coal Miner. The Hazelwood versus Coal Miner decision noted that the rights of the students are applied in the light of the special characteristics of the school environment. In Fredrick's defense, they also referred to the Tinker versus Des Moines Supreme Court case, where they ruled in favor of the students. They decided that the students' First Amendment rights do not stop when they enter school property. The Supreme Court case of Morse vs. Fredrick teaches us that school authorities do not violate the First Amendment when they stop students from expressing views that may be interpreted as promoting illegal drug use.
The Morse vs. Fredrick case did not end with the Supreme Court ruling. The plaintiff decided to take the case to the Alaska Supreme Court on the grounds that the school violated the state's constitution. This was never resolved because both parties entered an agreement which rewarded Fredrick $45,000 to drop the case. The school district was afraid the Ninth Court would rule in favor of Fredrick and make it more expensive. In terms of free speech in schools, Morse vs. Fredrick is the most recent Supreme Court case, but other cases in the circuit courts, like Lowry vs. Everard, upheld that the Morse vs. Fredrick case did not overturn or restrict the First Amendment right protected in the Tinker case.
I personally think the Juneau Douglas School should not be permitted to punish the students who held the Bong Hits for Jesus sign at the Olympic parade, considering they were nowhere near their school grounds, representing their school, or required to go with their school. They are simply exercising their freedom of speech. If I were an educator from this school, though, I could see where the embarrassment would come from, or if a parent of a young child in the district had seen the students holding the sign or wearing their high school gear while doing so. But they weren't obviously representing Juneau Douglas. I don't think the school should have gotten, or the court should have gotten the school involved any further.
This next video clip shares the opinions of the people protesting and or attending Joseph Fredrick's hearing.
I'm here to support free speech.
Stay ho ho! Hey hey! Free speech in schools has got to stay ho ho! Hey hey! Free speech in schools has got to stay ho ho!
Well, I'm here because I believe in First Amendment rights, and I believe that those rights apply to students as much as they apply to other people.
Following Tinker, schools have been favored in freedom of speech cases, and we're going to see today if that trend continues or whether or not we're going to see a reversal. So this case will be very important.
Also, I think it's really interesting that it got here today. I thought free speech is pretty cut and dry, that you're able to have free speech in America, and I just wanted to see what would happen.
I'm actually a high school teacher, and I'm inclined to side with the student on this one.
And I think everyone deserves a right to have a say of how their society is run, as long as it's within the laws. And
there's some students right here from Georgetown who are here. It'd be like if they put up a protest sign and their professor gave them an F on the paper they're supposed to write, just simply because they exercise free speech rights while not on campus, not during school.
Good morning. We came here to the Supreme Court because we had a deep concern about what the argument on the other side might do to free speech in this country for many, many thousands of American citizens.
You have to be really careful about the kind of standards the court sets forth, because what's being advocated would really wipe out 40 years of case law and protections for basic free speech across the country.
We need to encourage students to speak up in the schools and to have free speech rights, and so I'm here to encourage the court to rule in favor of students' right to free speech, And the young man that unfurled the banner had a lot more to say than the message that was on the banner itself. I've spoken with him, and I am quite clear that he was speaking up for the right of all students to free speech.
Thanks to the 2007 Morse vs. Fredrick case, the First Amendment permits schools to chastise students at or across the street at a school-supervised event if the students are advertising in any way illegal drug use.